In 1999, Lalaine and Eric were married. They had a son, but they had their marriage annulled 5 years thereafter. When their marriage was annulled, the court granted the child's custody to Lalaine, but Eric was given visitation rights. Since then, Eric was based in the United States of America. According to Eric, every time he would come home to the Philippines twice a year, his former wife would deprive him of the chance to be with his son. When Lalaine and his son went on a vacation, he tried to contact them through Lalaine's relatives, but the latter would give him a runaround and would never allow him to talk with Lalaine and her son. When Eric wrote to his former wife, he asked that he be given the chance to be with their son every time he spends his vacation here in the Philippines. Lalaine answered and told him of her refusal to accede to his request, since she knows that their son would only feel bad and lonely when it is already time for Eric to return abroad. Eric countered that there are families whose children are left here in the Philippines since the father keeps a job abroad. All he is asking for is to be given the opportunity to spend his regular Philippine vacation with their son. Lalaine continuously refused to allow their son to spend time with Eric. Actual visits at home was not given to Eric, and he cannot even bring him outside. Eric is asking what he can do to exercise his visitation rights. Eric, you may very well fight for your visitation rights for your son, as the court in your annulment case granted you visitation rights. You may file a motion before the court to execute or insist on that court-granted visitation rights. In the case of Silva versus Court of Appeals, GR number 114742 on July 17, 1997, it was held that parents have the natural right as well as the moral and legal duty to care for their children, see to their proper upbringing, and safeguard their best interest and welfare. This authority and responsibility may not be unduly denied the parents, neither may it be renounced by them, even when the parents are estranged and their affection for each other is lost. The attachment and feeling for the offsprings invariably remain unchanged. Neither the law and the courts allow this affinity to suffer, absent, of course, any real, grave, and imminent threat to the well-being of the child. Be reminded that our opinion is based solely on the information you provided us and may change depending on any additional information. You will be free to consult a lawyer of your choice regarding your legal concerns. Email us at ptv4newscenter@gmail.com. Attorney Jimeno, Atienza for the Rule of Law.